Hello, my name is Silashi Hirko. I'm a postdoctoral researcher based at University of Ottawa, and I'm a visiting scholar at AI for Good Foundation. My background is IP and competition law. Today, I'm going to present on the relationship between artificial intelligence and copyright. So the title of my presentation is Artificial Intelligence, AI, and Copyright in the Context of Big Data. So I would be looking at the relationship between AI and copyright from human rights perspective. To begin with the relationship between AI and copyright in general, I would be looking at AI and big data, how AI and big data would relate to each other. AI is an emerging technology that is essentially based on big data for its design, for its development and implementation. So big data is actually an essential input for the functioning and implementation of AI. So that is how AI and big data are inextricably related to each other. And big data can be developed from data that are protected under intellectual property, as well as personal data. Looking at the relationship between AI and intellectual property in the context of big data is quite broad, so I would be focusing only on one form of intellectual property, which is copyright. So how do AI and big data relate? That's what I already mentioned. And big data is actually known for this four essential features, like in terms of the size, the volume of the data is quite large, and the variety of the sources for the data that would be collected, which consists of the big data, and the velocity, that means the speed at which big data is collected, analyzed, and processed in general. And given the increasing value of big data, the value of big data that would be utilized in the process for various purposes is also another characteristic feature of big data. So moving on to the relationship between AI and copyright, this would be explored in the context of big data, as I mentioned already. So the first point is, how does AI and copyright relate to each other? AI is used to perform specific tasks, and performing specific tasks might involve like generation of creative works, and those creative works that might be considered for protection under copyright. But more importantly, the relationship, which is quite clear, is in the context of the inputs for AI, where the input for AI, which is part of the big data, might be subject to copyright protection. So copyrighted works as elements of big data might be involved in the utilization, and as well as in the implementation or development of artificial intelligence. And the other possible link between AI and copyright is in terms of the outputs of the artificial intelligence that would be generated from the machine learning. And the question is, would it be eligible for copyright protection? And there is debate on this regard because under the existing copyright system, creative works are protected under the copyright system only if they are original. So originality is one of the requirements under copyright law. And other important point is copyright would be vested in the author, and the notion of authorship is linked to human beings. And for machine-created outputs, the outputs may not qualify for protection because it doesn't actually fit into the very notion of human authorship. And the other element which would also still be an issue in the protection of machine or AI-driven output is a requirement of originality, and originality is not defined under the existing IP system, like in the copyright law, but courts determine on case-by-case basis, and usually they consider the level of human creative effort is involved in developing the creative workers. So purely machine-created workers may not still qualify for protection for want or lack of originality. And the other important point with regard to the relationship between AI and copyright is the exception of text and data mining, where copyrighted works would be extracted for the purpose of utilizing AI. And that involves an algorithm-driven process called text and data mining. And several jurisdictions have already adopted this as an exception for the purpose of using AI. And this is actually not existing under copyright law in general, but nations have adopted this as a specific limitation, which would facilitate access to copyrighted workers for the purpose of AI, particularly for non-commercial research purposes. And the other important point I'm looking at is AI, the interface between AI and copyright in the context of human rights. Copyright has a human right dimension under the International Covenant on Economic, Social, and Cultural Rights. Article 15 of the Covenant provides for authors human right over material and moral interests arising out of creative workers. That refers to authors' moral rights and authors' economic rights over creative workers, which are recognized as human rights dimensions of copyright. And this human right dimensions of copyrights, economic rights includes like a right of reproduction, translation, and other economic rights, such as rental rights, whereas author's moral right includes the author's right to be recognized as the author of that specific work, which relates to the notion of authorship, and protection of the workers against acts of distortion and mutilation, which is called as right of integrity. And these are the moral rights of authors, and they are recognized and protected under international human rights law. And authors' rights are provided along with others' human rights, and I refer to these other human rights as users' rights. And this includes the right of everyone to culture, participation in cultural life, and participation in cultural life involves utilization of copyrighted workers as cultural goods. And the other important human rights provided along with authors' right is the right to benefit from scientific progress and its applications. So that is another important user right, which has a human right dimension. And the third important right is right to freedom indispensable for scientific research and creativity. And these three human rights are provided along with authors' rights under that same article, Article 15 of the International Covenant. And therefore, protecting human rights necessarily involves the need to also take into account users' right to participation in cultural life and to benefit from scientific progress and its applications, and as well as users' right to freedom indispensable scientific research. And there is a need for striking a balance between authors' rights and users' rights. and balance should actually be strictened in the sense that both authors and users' rights would not be violated. So authors' protection of the workers should be balanced against users' rights to access those protected copyright workers. And this is very important in the context of artificial intelligence, because access to those copyrighted workers without deauthorization or without appropriate limitations and exceptions might infringe authors' human rights. And at the same time, restriction of access to those protected workers might also violate users' right to cultural participation or to benefit from scientific progress and its applications. This would lead us to concluding remarks, given the relationship between AI and copyright, both in the context of big data and as well as their human rights implications. There is a need for reforming the copyright law to introduce appropriate limitations and exceptions. There is no harmonization of limitations and exceptions under the existing international copyright system. And in particular, the limitations and exceptions that are very important to facilitate access to protected workers for the purpose of artificial intelligence is the text and data mining. And this has been adopted in several jurisdictions such as France, Japan, Germany, Singapore, and the United Kingdom. And at regional level, the EU has also adopted this exception for non-commercial research purposes. And that is actually criticized somehow in the sense that there are limitations provided against the text and data mining because the right holders might reserve this right, and that would limit users' access to big data using text and data mining. And the other important reform is, which is actually very necessary, is regulating artificial intelligence to minimize risks and to promote the positive contributions of artificial intelligence. Artificial intelligence is very important to promote creative innovation, but it has got a lot of risks that needs to be regulated. So policy and legal frameworks would be important to regulate artificial intelligence to promote this positive contributions while minimizing associated risks. And in this regard, I suggest taking human rights approach to both reform the copyright law and introduce appropriate limitations and exceptions, and as well as in the policy and legal regulation of artificial intelligence. And this would actually facilitate harmonized and reasonable access to protected workers for the purpose of artificial intelligence. Thank you for your attention.